Finally, Parliament approved Justice Baffoe Bonnie as Chief Justice of the Republic of Ghana. Etoja ene minority ni majority. The Speaker of Parliament etro huntonto. Na se see de Ghana say bibia nu e because of Parliament showdown take place. Ene showdown point between minority and majority no. Penny Beshe, Nanya Sam Ketwa, Yabudum, Eddie Amau, Nana Jantua TV, Mpacho, click subscribe button, we have bell notification icon, or better no video drop here, be the first person to get it. Video no share in Mpacho, or like or comment in the comment section what you make of the video. Now first watch share na for front so anya be a share. Mpacho menya person minkum share na amanfo anya be share. Now no Monday, Anna Justice Baffoe Bonnie, acting Chief Justice then, a copy of Parliament, Emir Covetin. Now him say vetting a question crano. There was a clash between minority leader Afenyo Markins and the majority leader Mahama Yarega. And ne Anna Parliament a question huntunto. Reports from the appointment committee no. Omodi beto ja minority no ombejetum and as a majority no ebejetum and as omunyintum. And ne Anna beto ja. Na me say a shasi no. Nenyasem kutakra. Dr. Dominic Ayine, Attorney General, no Parliament, also advancing the arguments. We na no see ana uso wakasana na minority leader Afenyo Markins ebe bogram or den sembe tuja. Dr. Dominic Ayine den sembe tuja. Menye nsem ne nka me wakotie Dr. Dominic Ayine, Attorney General, one Afenyo Markins mo modi tuja abra no copy of Parliament on Chief Justice Baffoe Bonnie.
The judiciary. Mr. Speaker, I am sure the minority will, do well to listen to what I'm going to say. Mr. Speaker, he gave us three cardinal pillars on which he is going to transform the judiciary. He said he is going to introduce rules relating to procedural clarity and flexibility. Second, he is going to introduce efficiency in justice delivery. And third, accountability at all levels of judicial decision making. This is what we need at this point in time in our history. This is what we need for the judiciary to be independent and to perform and deliver justice to the people of this country. Mr. Speaker, on the issue of pending suits, I am, or let me say my office is, a nominal defendant in all the suits. And I know better, looking at the Constitution and our standing orders, than to comment on pending suits before the courts of justice, whether it is the ECOWAS court or it is our own, judiciary. But, Mr. Speaker, I want to assure this House and all Ghanaians, our citizens who are listening to us, that nothing untoward, no untoward conduct has emanated from my office. And the minority, with all the experienced lawyers that they have, including but not limited to the Honorable Minority Leader himself, should know that if the Supreme Court comes out with its decision saying that the process of the removal of the Chief Justice was groundless, in other words, there was no ground, there were no legal grounds for the removal. Mr. Speaker, no, listen to this. If orders are made, the President of the Republic, His Excellency John Dramani Mahama, has no option but to obey the orders of the court. In fact, if he does not obey, the Constitution says that is a high crime.
Honorable Minister and Attorney General, this is an area that I've given a directive on. You have to move away from it and let's focus on the matter before the House.
Thank you, Right Honorable Speaker.
Minority Leader is on his feet, yes.
Speaker, with respect, my respected colleague, the learned Attorney General, made reference to me in his submissions. To the extent that I feel misquoted, I just want to take the opportunity to correct the fact on record. He contends that the minority, with all its lawyers, including me, have misconstrued the matters at the various courts, and goes on to make further submission that should there be any ruling in favor of the plaintiff, Her Ladyship Justice Tokonu, Mr. President would obey. Mr. Speaker, the gravamen of my contention and that of my colleagues is to the effect that the learned Attorney General's office, with the time given to file defense in the suit, has failed to do so. That was the argument of bad faith we raised, that in ECOWAS court there's a time, and if we really want to enrich our constitution and you've created a certain lacuna, you've created a certain situation that goes against the rights of the respected former Chief Justice. That was the contention. I was not raising any other thing but rightly saying that if you had failed on time, especially when you were served with all the processes on time, look at the way the injunction application was speedily heard. The substantive matter was pending long before vacation, and even after legal vacation, you didn't file a defense. You later went to the court to file a process for leave for extension of time, to file your process out of time. Meanwhile, we were receiving a nomination. Meanwhile, Parliament was again bound to hear the nominee. This was the argument we made, and it was not to attack the issue before the court. It was the action of your office, and that is why we raised it. So, Leonard Attorney General.
Minority Leader,
yes, Mr. Speaker.
We have heard you. Heard you.
Very well.
Please, I was compelled to give him time because you referred to it. And it's not a matter, as I directed earlier on, that is of concern to the motion that is before the House. So kindly move away from there and then make your submissions. I will definitely, I've taken note of the interjections, and you have enough time to make your submission. Please, you may go on.
Mr. Speaker, thank you very much. There is a point of correction, and because we are a house of record, Mr. Speaker, I think it is very, very important. The Honorable Minority Leader himself knows very well that the rules of court, CI 16, supplemented by CI 47, the High Court Civil Procedure Rules, accords lawyers the opportunity to apply for extension to file their processes out of time. This is not something strange, and there is nothing sinister in what we have done. So, Mr. Speaker, in rounding up, I wish to employ all of you, my colleagues in this House, that we approve the President's nominee because he is ably and eminently qualified in terms of Article 128, Clause 4 of the Constitution. He is one of the most experienced justices of the Supreme Court that we have, and his experience is definitely needed at this point in time in our history in order to
Honorable. Afanyoma kene Dr. Dominic Hayini Anusien. Afanyoma ke besa babiem. Na a Greek minister, Dr. Eric Opoku, na our parliament no. Wasi the hypocrisy of the MPP ni wantiase. Debi. Na monkai 2008 and niema ekoso Ghana ha under President Kufuor mu refiana. Na nanse ya kwa niema akoso asemo dane mano ene mo in favor of one trend. Ade ebechi the same trend no na minority. Mabasama no. Who ni say a hypocrisy on the part of the MPP. Now, at a point during his presentation, Okasa won ma the more parliament of making noise. Hey, no we are na afanyoma kesa bowramu na afanyoma kesa bowramu na no see ye ana mahama yarega. Ese ne munso ma de ekoi de eba ye komamo. O say na wontiase Uganda hanum say 2012 your election petition na ekoso na President Mahama teso. Enso kwa ne ye wie ye no. Ye gitu mu say si edi asem ni wie na Nana Akufo-Addo win court case na anka President Mahama betra nchen ama Nana Akufo-Addo be di president. Sanso na 2020 President Mahama lose election Akufo-Addo ene na president. Ye NDC for the court. Ghana for you to say President Mahama win sa Supreme Court case na anka Akufo-Addo betra nchen ama President Mahama be di aba no. Ana be di president no. Na fei se president di boku eje tumu se ye be sa ade na Chief Justice ni issue court a adante ni yentimi ni substantive Chief Justice. Se Justice get to Tokonu eko win the Supreme Court case na anka Chief Justice Paul Baffoe Bonnie betra nchen ama na be di akonwa no. Etidi entina yes a comparison one tiase se parliament we kwakwe da ware ye twe no srane abasa debi Mahama yarega ede nsem etudwa ye nkwati omu nyina.
Thank you very much, Mr. Speaker, for the opportunity to contribute to the motion before this House. Mr. Speaker, this House is witnessing inconsistency in its highest apogee. Inconsistency that has never been seen on the floor of this House, except today. Mr. Speaker, you recall that in the last year of Mr. President John Agyekum Kufuor, 2008, Justice Paul Baffoe Bonnie was elevated to the position of Supreme Court Justice. And the Appointments Committee's report was submitted to this House for approval. Mr. Speaker, that day, records of this House indicate that the minority we see today, they were in the majority. And they extol the virtues of this man right in this chamber. They describe him as competent. They describe him as competent, a man who has served this nation with dignity, an honest judge. In fact, they said a lot of good things about this man. Mr. Speaker, what has changed? What has changed? Today, the same person has been elevated, and now you are opposing his nomination. History will be the best judge. Mr. Speaker, again, I heard Honorable Enyimadu spoke about executive manipulation of the judiciary. Mr. Speaker, you recall that between 2003 and 2006, Justice Paul Baffoe Bonnie was appointed to the Fast-Track High Court. He was appointed to the Fast-Track High Court, a court established by President Kufuor, tried some cases, and after some years, declared unconstitutional in the history of our country. That was the period of executive manipulation of the judiciary. That was the period. And it happened under your watch. And today you have the courage to sit in the same chamber and talk about executive manipulation of the judiciary. Mr. Speaker, again, you are ruling on the matter, on this matter, is fortified by this report.
Honorable member, please. May we listen? Honorable member, I ruled on that, so let's move on.
Mr. Speaker, I'm moving on because our colleagues, when I raised the issue, that the same person, when he was brought here, they extolled his virtues. They said no, they are not opposed to his nomination, but they are talking about some legalities. And the basis of their argument is that there is a case that is to stop the proceedings of this House. And I'm reading this to fortify your ruling that they don't have basis. Their argument is baseless. They are only talking because they are in the minority and they want to be heard. Otherwise, they'll have no case at all to be even making noise in this House. The truth of the fact is that the man qualifies, he is competent,
In fact, he's the first son from our region, Ahafo, to be elevated to this position. And the people of our region are solidly behind him. And so we urge our colleagues on the other side that you cannot oppose everything on this earth. You were here defending some few days ago. Now you are transforming.
A sitting Chief Justice has been removed pursuant to Article 146 of the Constitution. Mr. Speaker, that removal effected on 1st September 2025, following recommendation by a committee chaired by His Lordship Justice Gabriel Puaman, has generated unprecedented litigation challenging its constitutional validity, procedural regularity, and legal effectiveness. Critically, several proceedings were filed before her ladyship's removal was finalized. These are contemporaneous constitutional challenges asserting fundamental and irredeemable flaws in the Article 146 process. The removal proceeded despite these pending objections. These objections now remain unresolved before multiple courts of competent jurisdiction. Mr. Speaker, we, the minority, hold the view that there has been inconsistency in the approach in this matter, and that if care is not taken, this country that we all seek investment for may not attract that needed investment. Mr. Speaker, as we speak, the prima facie findings of the Council of State remain unpublished. 2, as we speak, the very report that recommended...
Honorable Member, I thought your reference to this matter was a matter before the House.
Yes, Mr. Speaker.
But what you are talking about is not before the House.
Mr. Speaker, then let me use the phrase well. Let me rephrase it for the purpose of clarity. Mr. Speaker, my submission is to the effect that the matters giving rise for this motion to be taken are such that we, the minority, still believe that there are serious matters for the Constitution of our Republic. Mr. Speaker, and I say so because today we consider this nomination, and you have made it clear that our approval or otherwise does not bring a finality within the context of the rule of law, which I agree. I'm not contesting that. But it is our view, most respectfully, that one, the fact that the prima facie determination is not in the public space is of concern to us. 2, the fact that the recommendation, the report that gave rise for the final decision of His Excellency the President is also not in the public domain is of concern to us. Mr. Speaker, we contend that for the purposes of transparent democracy, the era where the citizens require information, it should have been an instinctive, inherent decision to have released a report. Because, Mr. Speaker, we hold a view that this was no less a matter because it was dealing with an organ of government, of state, the judiciary. That is our contention. Mr. Speaker.
Honorable Member, as I said, you are complaining about acts of another arm of government.
Mr. Speaker, I hope my time is being stopped.
Not Parliament. Not Parliament.
No.
And those matters are not before Parliament. And so I have consistently guided you and your colleagues to deal with the matter before Parliament. Continue with the others at the proper forum, not the floor of Parliament.
Mr. Speaker, we are not litigating those matters in Parliament, but those matters gave rise to this, what is before us. So what I'm trying to do is to give a background to the very matter before us, Mr. Speaker. Mr. Speaker, the Honorable Eric Opoku in his submission argues with some force that executive manipulation started in Kufuor era. I found it very rich. And he tries to use that to justify the concerns that we are raising, to say that we are acting in double standard. No, Mr. Speaker, in President Kufuor's era, no Chief Justice was removed. Mr. Speaker,
Honorable member,
Mr. Speaker,
please. I don't want us to go beyond what is before us, because many of the things that you say, because many of you were not born early, you don't know, you don't have the information. And in fact, I have bought some books, and I'm going to distribute the book.
And for Parliament, the election results were disputed. President Akufo-Addo was declared winner. John Dramani Mahama and the NDC petitioned President John Dramani Mahama was declared winner. Akufo-Addo petitioned the courts. Mr. Speaker, in 2020, we had another election, and President Akufo-Addo was declared winner, and John Dramani Mahama petitioned. The cases traveled before the Supreme Court, and finally, the Supreme Court made a pronouncement. Mr. Speaker, it was clear to every Ghanaian that in spite of the cases pending in the Supreme Court, we went ahead and swore in those declared by the Electoral Commission as having been validly elected. But the case went on, and in the case of the petition against John Dramani Mahama, it was in August 2013 that the Supreme Court handed a ruling. Mr. Speaker, when we put the question to the nominee as to what he thinks will happen if the previous Chief Justice's case turned out in her favor, he simply referred us to these two cases. If in a presidential petition, we are convinced that if the ruling goes against a sitting president, that person will vacate the seat so that the winner will take over. Why would we entertain doubt that if a Chief Justice who has left office gets a ruling in her favor, that the sitting Chief Justice will not give way so that the decision of the Supreme Court will be enforced? So the answer is simple. We have to proceed. And when the decisions of the courts come, and the implications are that what has happened should be reversed, the Chief Justice nominee said he is ready to give way, and whoever the courts declare in favor of will come and occupy the post of Chief Justice. So there's no problem. Mr. Speaker, the second issue about the listing of cases was put to the nominee, and the nominee explained that he, as acting Chief Justice, is not responsible for listing cases. So if the minority's position was that some cases hadn't been listed, then that is a matter for the registry, because as an acting Chief Justice, the Chief Justice normally empanels the court when the registrar indicates that all the processes had been concluded, and then we had reached a stage where we would need to empanel a court. So he wasn't responsible for cases not listed. Mr. Speaker, I think that a lot has been said already about the nominee, and I will not belabor the point, except to once again, lastly, register the point that in 2012, July 24th, 2012, Justice Theodora Wood was nominated, approved by this House, and appointed a Chief Justice. 2013, January, President John Evans Atta Mills, under the NDC, became president. He coexisted amicably with Justice Theodora Wood, who was appointed by President Kufuor under the NPP. Mr. Speaker, again, on 24th of July, 2012, when we lost the president, John Dramani Mahama took over as the president, and he coexisted amicably with Justice Theodora Wood.
Abusiafo, omu nyina no siye no, ana Speaker of Parliament, Alban Bagbin be rule ye. Omo ye ni no. Abusiafo, owie ne titi ane say, ye for na wini. Yenko Speaker of Parliament, Alban Bagbin.
Honorable members, I put the question again. Those in favor of the adoption of the report of the committee, say aye. Those against, say no. Honorable members, I think the ayes have it. Honorable members, we have the Honorable Deputy Whip, Minority Deputy Whip on his feet. Let's listen to him.
The PM Parliamentary no yadamu nyina se mo hwe adwumadie so kato show na atwagu e wona na Jantua TV. Mpacho we new click subscribe button ma we bell notification icon wa tell on video drop here on sa ebeka na Jantua de so kato man enche mo beten nka right here on Nana Jantua TV. Until we meet again, makramo.